Welcome back to Sunday Night in America. Certain rights are mentioned in the Constitution. Other rights, like marriage and the right to contract, are not mentioned, but are considered fundamental and firmly rooted in the history and traditions of our country. Still, other rights may or may not exist, but whose job is it to identify those rights? The Chief Justice of our Supreme Court once wrote, "This court is not a legislature. Judges have the power to say what the law is, not what the law should be." The people who ratified the Constitution authorized the court to exercise neither force nor will, but merely judgment. So what is the proper role of our judiciary, and how does it keep that role when both sides seem to want it to do more? Joining us now is chief legal correspondent and host of Fox News at Night, Shannon Bream. Shannon, this is not an easy question, but it's an important question, and you are the perfect person to take us to law school. Certain rights are mentioned in the Constitution. Others, like marriage, are not mentioned, but are considered firmly rooted and historical. But then we have the Supreme Court saying, but other rights we're going to send back to the legislative bodies in the states to figure out whether that right exists or not. How are people supposed to know the difference between what's a right, we can read it, what's a right, even though it's not in the Constitution, and what the states get to decide?
Yeah, this is so tricky. We should make you Justice Gowdy, and then we could put this all to rest. This is tricky stuff because we know we can read the text of the Constitution and you know what it says about life, liberty, and the pursuit of happiness and all of those things. But there are rights, as you said, over the years that our courts have found are historic in nature. We saw a broad discussion of this in the Dobbs decision, the one that just overturned Roe v. Wade days ago, about what history said, about what practice was. And, you know, Roe said in 1973 that there was a right to privacy and that within that there was this right to abortion. And so, you know, the court went through a long, methodical process of looking through history and looking through tradition and said no. At least 5 of them, the majority said there is not a constitutional right under the U.S. Constitution to an abortion. This should go back to the states. We want this to be closest to the people who are elected to make decisions for the citizens of this country. So we've got 50 laboratories of democracy that are now going to wrestle with their own state constitutions and with their own state laws as to how they find this balance on the issue of abortion.
You know, I went back after Dobbs, I went back and reread Chief Justice Roberts' actually dissent in the same-sex marriage case. And he said you can celebrate whatever you want to celebrate, but don't celebrate the Constitution, because the Constitution has nothing to do with same-sex marriage. I think what people are trying to figure out is this whole substantive due process thing, and who has the list of what's considered a right and who doesn't.
This is why it is so tricky. And we count on, at least at the highest level, these 9 judges who have become justices, who have, we hope, been vetted by years of experience, either in academia, preferably on the bench for a lot of people, so we can see what they're going to do. They wrestle with these questions. It's why we end up with 6-3, 5-4 decisions all the time, and plenty of them in the last few days, because these are questions of philosophy and judicial philosophy and how you parse those things out. And for so many of these tough questions, as you said, it goes back to the states. We look at history. We look at, you know, when you're deciding a question at the federal level, you know, they'll go through and have this examination. What were the states doing at the time? What was historical practice? This was one of the concerns that the late Justice Ginsburg had about the Roe decision, that states were moving on their own in these conversations about abortion, for example, and that when you short-circuit that process and take it away from the states, she worried that the legal underpinnings of Roe, in light of those conditions, were in danger. They were vulnerable, and she was right about that, because this is where we've ended up. But man, I wish those questions were easier. I might have done better in law school if they were.
And I think these matters are going to be right back before the court, but you're a better lawyer than I am. I mean, could a state say, rape victims, you have to carry the pregnancy to term and you cannot cross the state line to go have an abortion? Is that possible in the aftermath of Dobbs?
I'm not saying that no state legislature would try that. I haven't seen any legislation with that kind of language. I mean, there are very limited. I mean, listen, there are states that say from conception, we're protecting this, we view it as a life, and you're not going to have a right to an abortion here. I've seen nothing, though, about crossing state lines, because I think you and I know that then you get into the interstate issues and the issues of equal protection. And I think, yeah, that would be a whole nother situation. But we do have these questions about, medicated abortions, whether you can order pills in different states, where some states are going to ban that form of abortion. Could they go through the mail system? There are federal statutes on that. So I do think if anybody thought this decision was going to end the discussion, I think what it did was reopen what was happening in the lead up to Roe, which was states wrestling with this. Roe may have stopped that for 50 years, but I think it's just reopened that wound, and these conversations that were bubbling then back in the 70s and the 60s are now going to start afresh.
I got to have you back when it's not July 4th weekend and we can talk about it more. But thank you, Shannon Bream, for shedding insight on these complicated legal issues for us.
Good to talk with you, always.